The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Welcome to Deep Dive with the Institute for Justice. I'm Melanie Hildreth. A controversy about almond milk and veggie burgers may not sound like a very big deal in 2020, but there's an ongoing debate about how the government can regulate the way that companies talk about these products that actually has a pretty big impact on free speech. So I'm here today with IJ senior attorneys Justin Pearson and Paul Sherman to talk about what's happening and why it matters. Justin, can you start us off by talking about a case that you filed actually just this fall on this very issue in Oklahoma? What's the law that you were challenging, and why did you think that it was bad enough that IJ needed to sue about it?
Well, so it was a law involving labeling requirements for veggie burgers and other vegan foods. But really at the core of this was something we see a lot in our economic liberty litigation, which was that a giant trade association teamed up with the government to hurt its competition. Now, protectionism is not a legitimate basis for a law, and that's particularly true when the First Amendment is involved. And so what happened in Oklahoma was that, like every other state, Oklahoma already had laws prohibiting fraud and misleading speech and misleading labels. And the vegan food sellers had no problem with any of those laws. But the Oklahoma Cattlemen's Association went to the state legislature and had them pass a law that said even if no one is being confused, they had to change their labels. The vegan food sellers had to change their labels just for Oklahoma to make the words vegan much larger than they appear anywhere else in the country. And so this would impose a tremendous cost on the vegan food sellers, many of which they can't afford to do just for Oklahoma. So they're going to stop selling in Oklahoma because of this law that was passed simply to hurt competition. And that's why we filed this lawsuit, to get rid of this unconstitutional law that doesn't accomplish anything. All it does is make the vegan food sellers revamp their labels just to tell people something they already know in a different way. It doesn't make any sense.
Part of the reason this has become an issue now is because the quality of vegan food has improved dramatically in the last few years when it comes to things like veggie burgers and things like that. Whereas it used to be that, veggie burgers were not something that people were going to seek out unless they were really hardcore vegetarians. Now, some of these products are starting to appeal to traditional meat eaters, and people who raise cattle see that as a threat.
So the regulation itself, Justin, it seems like, well, these people should be proud, of their food. This is no meat food. This is what they want to do. Like, what's the big deal about making the word vegan a little bit bigger?
So you're absolutely right. They are proud. And that's kind of the point. They're already proud. Their labels are already clear. And if the government's going to make you change your label around, it needs to have a legitimate reason to do so. And the fact that a powerful trade association wants to hurt its competition is not a legitimate reason. And so this really highlights something fascinating going on with commercial speech jurisprudence right now, which is the evolution of the burdens for restrictions on commercial speech, including what's called compelled commercial speech, when the government makes you include words on your label. The Supreme Court has recently clarified that the government bears the entire burden whenever it wants to do that. And this case, I think, illustrates why that's so important, right? Because I get how some people might say, what's the big deal? Just say these things you're already proud about even bigger. But again, the government bears the burden here, and they haven't done anything to meet it in this Oklahoma case. And so under the First Amendment, that means that since there's no real legitimate reason for this change in the law, the vegan food sellers shouldn't be forced to undergo the time and expense and sacrifice. They've put a lot of effort into these labels to make them as clear as possible, and that shouldn't be sacrificed just because their competitors want to hurt their competition. That's not a legitimate basis for a law.
One of the things that I thought was interesting when you launched the case was pointing out that the requirements actually, that the only other place that this exists most of the time is things that are dangerous, like cigarettes, where you have the giant Surgeon General warning. That it seems kind of crazy to have these healthy natural foods that are being sort of regulated the same way as cigarettes, simply for these sort of protectionist reasons.
That's exactly right. And there, for cigarette labels, because it's a dangerous product, the government gets a little bit more latitude. And here, I'm not even saying the government's never allowed to regulate speech, even if it's safe speech. But they have to have a legitimate reason. The law has to further that reason in a real way, and it can't be more burdensome than necessary. What can't happen is the government going around making overly burdensome requirements that accomplish nothing just because special interests ask them to. That's totally unacceptable.
And this is one of a series of cases that you've done on this sort of issue. One earlier, I think last year, was in Mississippi. What makes the case in Oklahoma different from the one in Mississippi, which you won pretty quickly?
Right.
Can you talk about that?
Yeah. So what's going on now is that the trade associations are pivoting their strategy. So we won our case in Mississippi. That was a full ban on terms like veggie burgers and vegan hot dogs. And just a couple months after we filed that lawsuit, Mississippi totally threw in the towel. And which was great. There are also other cases around the country. Tofurky recently obtained an injunction against a similar law in Arkansas. And so what happened was the cattlemen's associations realized that all of these bans were being ruled unconstitutional, or when they were being challenged, the state would realize it was going to be ruled unconstitutional and throw in the towel. And so they changed their strategy. Instead of doing a full ban, they said, well, let's just compel these giant disclaimers that make our competitors revamp their labels at tremendous expense. And so that's their new approach. And so we have to pivot our approach as well, because that is just as egregious in my view, right? It's still big government teaming up with big business to hurt those big businesses' competition. That's not the proper role of government. And so we're taking on this new approach, which is also unconstitutional.
It illustrates also, I think, an important aspect of the First Amendment that is often overlooked, which is that the First Amendment doesn't just protect your right to speak, but it also protects your right to decide the content of your speech. And that necessarily includes the right to decline to speak if there are things you don't want to say, or if you don't want to express yourself in a particular way.
So that's actually one of the things that I wanted to ask about, Paul, is, as Justin was talking about the cases in Oklahoma and in Mississippi, we're talking about them both as sort of this protectionist issue, but then also as a speech issue. So I wondered if you could talk about why this is something that as lawyers you look at as a First Amendment issue, as opposed to sort of, why isn't this just simple? The government regulates the economy all the time. This is just one more thing that they're doing. How do you as an attorney make that distinction and make those calls as you're looking at these cases? Sure.
Well, luckily, it's a distinction that the Supreme Court has made pretty stark, particularly in the last few years, the last decade, really. Basically, if a law is triggered by speech with a particular content, that law is a regulation of speech and has to be analyzed under the First Amendment, regardless of what the government's motive is. So even if the government is only trying to regulate commercial regulations or whatever, they are limited in the means that they can choose to do that. And if the means that they select are the regulation of speech or the compulsion of speech, then the government has to satisfy the First Amendment. And so that's exactly what we see going on here. It's just the government trying to interfere in the marketplace using a different set of tools. Luckily for us and for our clients, it's a set of tools that is broadly unconstitutional. And so, we have better luck challenging these kinds of regulations than we might challenging a regulation that's subject to the rational basis test that ordinary economic regulations are subject to.
Yeah, that's so true. As someone who litigates both economic liberty cases and First Amendment cases, it's so refreshing in a First Amendment case to litigate a case where the government actually bears the burden and where facts matter and evidence matters. That's how it should be in all cases. There should be real judging in all cases, but sadly, that's not always true.
So when it comes to commercial speech, in particular, could you, Paul, maybe go back through a little bit of the history of how we got there? You said recently there have been some pretty bright lines drawn by the court, things that make it very, very clear. My sense is that wasn't always the case. Like, I had this impression that commercial speech was treated differently and may still be treated differently. And I wondered if you could talk a little bit about kind of how we got here.
So the first thing that listeners need to understand is that although the First Amendment is about 230 years old, First Amendment law is really a creation of the 20th century. So it wasn't until the 1960s that the U.S. Supreme Court first struck down a federal regulation as violating the First Amendment. And the biggest changes in First Amendment law have happened really in the last 40 years. Before that, the court was very reluctant to strike things down under the First Amendment, and one of the things that they were reluctant to strike down was any regulation of commercial speech. Commercial speech was treated as completely outside the scope of the First Amendment. So in that sense, it was treated the same way that we treat things like fighting words or defamation or obscenity or child pornography, all of these things that are entirely unprotected by the First Amendment. It was actually thanks to the work of public interest litigators that in the 1970s, the Supreme Court reversed course and in a case called Virginia Pharmacy first recognized that commercial advertising is entitled to First Amendment protection. What we have seen since then is that the level of protection that commercial speech gets has gradually increased until it has gotten not to the level that we protect political speech at, but to a fairly robust level where the government has an affirmative evidentiary burden. It has to come forward and justify its own laws. And if it fails to do that, the laws are going to be struck down. Since John Roberts became the Chief Justice of the Supreme Court, we've seen the court take, I think, an even stronger turn towards this more libertarian view of the First Amendment, where regulation of speech is really just something that has to be a last resort. It's not something that the government can turn to in the first place.
And I think that Virginia Pharmacy case, if I may, is a great illustration of what happens when you don't protect commercial speech and how consumers are harmed by laws that infringe on commercial speech. After the Supreme Court expressly held in 1942 that the First Amendment didn't protect commercial speech, what happened was something that at IJ probably wouldn't surprise any of us. Trade associations went around convincing the government to pass laws banning price advertising as an indirect way of preventing price competition. And that directly harmed consumers. And so in the Virginia Pharmacy case in the 1970s, the plaintiffs were actually consumer groups who were harmed by these bans on price advertising, who wanted them struck down so that in that case, pharmacies who wanted to advertise their prices would be allowed to do so because that would help consumers. And so, commercial speech, it's not just important for the speaker, although it is, but it's also extremely important for consumers that they be allowed to access this information and not have powerful interests censoring their competition.
Well, I was thinking as you were talking about sort of the positive trend here, that it's like that's the thing that we need to promote when we broadcast the podcast, is that everybody's looking for some good news, and this is like a bright spot to see the law progressing in such a positive way and something that has such important impacts on people's lives. The way that this affects your day-to-day life. One of the things that I wanted to ask you about, Justin, when you do the cases that you've worked on at IJ, you often talk about one of the issues at play, or one of the things that is so problematic, being the government thinks that it can decide what words mean. And I wondered if you could talk about why you see that as a problem, and where specifically you've seen that come up in litigation that you've worked on here at IJ.
Sure. So, it's a huge problem when you think about it, because the government can basically short circuit, or would be able to short circuit, the entire constitutional review process if they were allowed to just define words, right? And this is something that actually came up in a case that I litigated on behalf of a small all-natural dairy creamery named Cheesy Creamery, where Florida had defined the term skim milk. They'd actually copied a federal regulation that defined the term skim milk as having 3 ingredients. The first ingredient was skim milk. The other 2 ingredients were types of vitamin additives. If you didn't artificially inject those additives into your skim milk, you couldn't call it skim milk. And so we represented Cheesy Creamery, who sold this pure, pasteurized, but all-natural organic milk, including cream and the skim milk that's left over is skim milk. And when we went up to the 11th Circuit and won, the 11th Circuit opinion talked at length about how it would be problematic and an illustration of circular reasoning if the government would be allowed to change the definition of something and then say that you've committed fraud because you didn't follow the government's own definition, and therefore the Constitution doesn't protect you. But that's what Florida was arguing in that case. And thankfully we won. It was actually the first time anyone had won a First Amendment challenge against a food standard of identity in U.S. history, mostly because many of those regulations popped up in that period before 1976, when the Supreme Court reversed itself in Virginia Pharmacy, and too many lawyers had just not recognized that the whole approach to commercial speech had changed since then. At IJ, thanks to our wonderful donors, we're able to really follow the trends and do a deep dive, no pun intended. And and we realized that, wait a second,
as well as nerdiness here.
Yeah, and so we realized at IJ that all of these laws that people just kind of took for granted all popped up during this period in time when the Supreme Court wasn't protecting commercial speech at all. And under modern jurisprudence, O'Cheesy Creamery might actually win. That was Mary Lou's Creamery, O'Cheesy Creamery, just west of Tallahassee. And so we won. And it's really fascinating to me that now this precedent we created on behalf of a dairy farmer in the Florida Panhandle is the key crucial precedent relied on in all these vegan food cases. And so it's just why it's so important to have, a consistent principled approach to all types of constitutional law, because the precedent you create for one type of business or one type of speaker one day can be used by a totally different person the next day.
Well, the O'Cheesy Creamery case raises an interesting question that I wanted to put to you both, which is, I mean, does it matter either as a matter of principle or as a matter of law what the motivation is for speech regulations? I mean, because it seems like it's pretty clear in Oklahoma, in Mississippi, that it's protectionist. Like these are companies that want to shut down competition. I mean, a good argument could be made for, the Florida Department of Agriculture or the Federal Department of Agriculture when they're regulating like the ingredients of things and what how you define things, that they're just trying to keep people safe. That this is really motivated by sort of setting a standard for food purity or something, and that sort of paternalistic approach. Does it matter at all if it's straight protectionism, which is very like knee jerk, nobody likes it, versus just trying to look out for us?
Well, can I rebut that assumption that Florida was acting out of paternalism?
There
and
is
not
no
protectionism?
such thing.
So when we were up at the 11th Circuit in the O'Cheesy Creamery case, the International Dairy Foods Association hired one of the most expensive lawyers in the country to write an amicus brief. And I know some of the viewers and listeners might think, oh, well, isn't that so nice that this Dairy Trade Association came in on, a white horse to help out Mary Lou? Wrong. That's not what happened. They wrote an amicus brief saying Mary Lou should lose, that O'Cheesy Creamery should lose. And the reason is because many of the fights going on are not the government versus business. It's one contingent of businesses trying to weaponize the government to hurt another contingent of businesses. And so, for example, in the dairy industry, what you have is this big fight going on between giant dairy conglomerates and small craft dairies. And so the giant dairy conglomerates, they know that they can win on economies of scale. And so they want consumers to just think that all that matters is that you got milk, as the ad campaign that they pushed for said, and that milk is fungible and that therefore they can win on price. Whereas the small dairy farmers, they want you to care about where your milk comes from, care about the processes they use and things like that, and maybe even be willing to pay a little bit more to buy local and so on. And so it was actually these giant dairy conglomerates and their trade associations that push for these one-size-fits-all regulations that small creameries hate. And so then when little Mary Lou Wesselhoff in the Florida Panhandle comes along and challenges their handiwork, they try to defend the law, because this was not about government paternalism. It was about the International Dairy Foods Association trying to hurt small dairies like O'Cheesy Creamery.
It's historically kind of interesting that this case involved the dairy industry, because in the realm of economic liberty, the dairy industry has also been notorious for decades for trying to get these kinds of protectionist regulations passed. In the early 20th century, we saw it with the invention of oleomargarine, where the dairy industry was hugely concerned that it was going to displace butter, and so they got punitive taxes placed on it. One law that they got placed that was actually struck down was that, I think it was in Wisconsin, all margarine had to be dyed pink. And the court was like, the only reason you're doing this is to make it appear unpalatable. That's not legitimate.
Spam butter.
But on the flip side of that, there are cases like United States versus Caroline Products, which is one of the most important cases in Supreme Court history, and the case that established that unenumerated rights get a lower level of judicial protection. And that is a dairy industry case. That's a case where the dairy industry was fighting against the sale of so-called filled milk, which is skim milk from which the butterfat has been removed and to which vegetable fats have been added, like coconut oil. So this is just kind of what we're seeing now in the First Amendment context is sort of par for the course.
So we obviously the dairy industry, this is a big thing that's going on. We've talked about sort of vegetarian meats. And I wondered, as you look ahead, down the horizon, where else do you see these kinds of battles popping up? Is it exclusively in the food context or what's kind of happening in a broader lens?
Well, certainly it's not limited to the food context, and there have been cases. There are cases that are being litigated in court right now involving compelled commercial speech that do not involve food. There's a case out of Berkeley, California, involving a municipal ordinance that requires cell phone retailers to have this disclosure about the level of electromagnetic radiation in cell phones. And the argument against it is that even though every sentence in the disclaimer read in isolation is literally true, when you read the entire disclaimer, it creates the misleading impression that cell phones are dangerous, or that, keeping a cell phone in your breast pocket can lead to breast cancer. So we're seeing that there. We're also seeing it with things like the regulation of products containing so-called conflict minerals. And I think, as consumers become in some ways more concerned about the ethics of the circumstances under which the products they buy are manufactured, you're going to see increasing calls for regulation that requires companies to disclose on their packaging facts about the conditions under which the product was manufactured.
And there are also really two types of situations going on out there involving this issue of deciding what words mean and who gets to decide what words mean. Even in the food context, outside of veggie burgers and vegan hot dogs, there's a big battle brewing over non-dairy milk, where the trade associations for years now have been trying to get the FDA to ban terms like almond milk and coconut milk, and they appear relatively close to doing so. And obviously, if that happens, then there'll be a huge fight. And then outside of the food industry, we still see this issue pop up a lot with professional licensing. And so, for example, a couple of years ago, there was a case in Mississippi that went up to the Fifth Circuit over whether tire engineers, which is what they call themselves, at an oil change place, could keep calling themselves tire engineers even though they don't have an engineering degree. And the Fifth Circuit said, yes, they can, because in context, which is really important here, in context, no one was being misled by what these people were saying in the context of an oil change business. The same is true, of course, and that same precedent applies to what's going on in Oklahoma right now, just to bring it full circle. No one is being confused at all by the veggie burger labels used by our client Upton's Naturals, which is a small vegan food business out of Chicago. In context, there's nothing misleading at all about that language, which means it's protected by the First Amendment, which is why these compelled speech requirements pushed by the Oklahoma Cattlemen's Association, being done for no other reason than to hurt its competition, should be held to fail the First Amendment.
Paul, when you were talking about the Berkeley, the cell phone regulations, it made me think, as one does when they think of California, about other things that may be, problematic laws there. Have either you or Justin ever looked into the mandatory label at every coffee place? You go into a Pete's Coffee, you go into garages,
the Prop 65
because of the fumes. Yes, I was curious. Is that, because that seems like that would be, if you're the coffee folks, like that's a compelled speech that you don't necessarily want to put out, like the idea that perhaps your coffee could cause cancer or something, or contains items known to cause cancer to the state of California or whatever it is. Has that ever been challenged, or is that something that it's just the health and safety nexus may be a little bit closer? Well,
so for listeners who aren't familiar with this, California has a law that says that basically if your place of business has any kind of substance in it that has ever been found in any study to have any connection to cancer, or I think birth defects or something like that, you have to have this Proposition 65 disclaimer on your building. And so if you go to California, if you go to a parking garage, you're going to see this because there's auto exhaust there. If you go into a coffee shop, you're going to see this. What I think it illustrates, I'm not aware, maybe Justin is, if someone has directly challenged it, but what it illustrates is the limits of what you can accomplish with these kinds of disclaimers, because what has happened is that these disclaimers are so ubiquitous that everyone just ignores them. They don't provide any useful information because, if you tell me that I'm exposed to a risk of cancer by standing next to a pile of uranium and by being in a parking garage, well, one of those messages is much more important than the other. And if you flood people with the parking garage message, they're going to ignore the uranium message. And that, I think, is exactly what we've seen. And there's empirical evidence that bears this out, that compelled disclaimers are not only ineffective often at informing people of what they need to know, sometimes they're even counterproductive.
Yeah, that's exactly right. And just two quick points to tack on top of that. It's not like there had been a shortage of disclaimers before the government got involved, right? Because there are class action lawyers out there. And the thing that really keeps many business owners up at night, it's not always the government. A lot of times it's the class action lawyers out there. They hate getting sued. And so there are already all sorts of disclaimers over anything that could potentially lead to real litigation, resulting from real damage. And then when you already have that overabundance of disclaimers addressing arguably real things, and the government comes and adds even more disclaimer requirements on top of it, it just feeds into the problem that Paul illustrated, which is that you're drowning out really important language by adding in all sorts of other ridiculous stuff on top of it. And the second thing is that, as Paul mentioned, there's actually empirical evidence showing that these disclaimers can actually be counterproductive, can actually increase consumer confusion. And Paul and I actually wrote an amicus brief talking about this on behalf of a Wharton School marketing professor, Scott Armstrong, at the DC Circuit, talking about Professor Armstrong's research showing how oftentimes, and really the majority of the time, these disclaimers hurt consumers rather than help them. And so you can't just assume that disclaimers always help consumers. In fact, more often than not, the opposite is true.
I think the answer to this is a little bit more apparent over the course of this conversation than it was at the start. But to kind of wrap things up, Paul, could you clarify for listeners, in a world where we're worried about cancel culture, and you have these high profile fights about technology companies and what they're censoring or not censoring, and what they should be allowed, what should or shouldn't be allowed on their platforms, and what their rights are. Why is this kind of speech something that is still important to worry about?
The reason that it's important is because we live in a commercial society and we live commercial lives. There is a common view of the First Amendment that it is primarily about protecting political speech or controversial speech or offensive speech. And the First Amendment does all those things, and it should do all those things. But the question that I like to put to people is, how many political decisions do you make in a day? Now, how many commercial decisions do you make in a day? How many commercial decisions do you make in a year? Can you even remember the last day when you did not make a decision about whether or not to buy something? So we live these commercial lives, and the free flow of information to help us make decisions and navigate those commercial lives is just as important as any kind of political speech that we could be exposed to.
Yeah. And that's not a new development, right? That goes all the way back to the founding and probably millennia, I would assume. But even in the founding, it was clear that commercial speech was really important to the founding generation. Ben Franklin's famous defense of free speech in The Apology for the Printers was about a commercial advertisement in a newspaper. It wasn't about a political article. It was about a commercial advertisement. And there's all sorts of other scholarly research on this issue where the founders understood that you have the natural right to sell your ideas, to advertise your ideas, to advertise your products. And it just sort of shocked them to think that there was ever a time where the Supreme Court would say that's not protected by the First Amendment.
Well, thank you both for your time, and I hope that you enjoyed the conversation. For all those who tuned in, if you did, you can find more episodes like it on YouTube or wherever you get your podcasts, and don't forget to subscribe.